You had your estate plan done 5 or 10 years ago. And when you did your estate plan, you were under the impression that after having signed all of those documents and funding your living trust, your estate plan was all done and that was all you ever had to do. If that is what you were thinking, this little educational video is meant for you. First things first, most living trusts have a name. For example, for David and Barbara Jones, their living trust title is David M. Jones and Barbara D. Jones as trustees of the Jones Family Trust dated March 3, 2005. This is the proper way to title trust assets because it does several things. First, it links David and Barbara Jones as trustees to the family trust. Notice that there is a date associated with the trust name. This is important because there may be lots of Joneses around. The date, in this case March 3, 2005, signifies when the trust was first created. Second, the listing of the trustees' names, David and Barbara Jones, lets the authorities know which person or persons can properly deal with this particular trust asset. If the Joneses' home were in the trust, real estate agents and title companies could see that David and Barbara Jones have the authority to enter into transactions involving the home. Remember, the trustees have to be linked to the trust in most titling situations. Okay, back to the subject at hand. It's important to remember that estate planning and tax laws change from time to time. If you do not have your trust reviewed by an attorney, certain provisions may be way too far out of date to be effective. If a problem occurs, you want to make sure your trust is up to date with any critical areas of the law. Another important reason to schedule a periodic estate planning review with an attorney is because your family situations may have changed. Your children may have been too young at the time to put in charge as backup trustees to you or to you and your spouse. Or your wishes may have changed. Maybe you want to leave a little something to grandchildren, or charities, or a sister or brother. By keeping your trust up to date, you don't unintentionally leave out someone you'd like to benefit in your estate plan. Without going in for an estate plan review, you may miss the opportunity to learn about new planning techniques. There are new economical ways to change your trust provisions so that your children's or other loved one's inheritance becomes virtually divorce-proof. By the way, if you're interested in something like this, please look at my little video titled The Marriage Protection Trust. This video is in the Learning Center portion of my website. Don't forget that when you amend your living trust, the title of your trust doesn't change. If the title was David M. Jones and Barbara D. Jones as trustees of the Jones Family Trust dated March 3, 2005, the amendment you're doing would not change that title or that date. You can even change the entire trust and keep the same title. In that way, assets that you have in your living trust will automatically be a part of your revised trust. It's worth having your estate plan reviewed every 5 to 10 years or sooner if you have any major life changes that need to be addressed or should be addressed in your plan. And don't forget about the other important documents in your estate plan either. Your healthcare directive and your durable powers of attorney and your other important documents need to be looked at from time to time. Those documents all should be coordinated as well. People you want in charge may be different now, or your wishes may be different. In any case, your entire estate plan should be reviewed periodically. Don't find out you have problems with your estate plan when it's too late. Well, there's not enough time to cover all the reasons why it's important to have your estate plan reviewed from time to time, and not just signed, put away, and then forgotten about. I hope my little video pointed out some of the things for you to consider. I'd love it if you'd share my video with friends and family. I'm estate planning attorney Hollis Logue.